I want you to stop what you're doing and really listen because the headline you've been waiting 5 years to see is finally flashing across the screen. Make no mistake, today justice has arrived. But I need you to look past the breaking news alerts because at exactly 10:47 a.m. this morning, something happened in federal court that changes everything. A sealed docket entry was unsealed, and what it reveals isn't just political gossip. It is the smoking gun in the obstruction case against the former president. We aren't talking about anonymous sources or leaks. We are talking about sworn testimony from the defendant's own spouse. Testimony that was provided in a sealed deposition and has now entered the public record. Before you dismiss this as just another raid, I want to show you the document itself. I've built cases for 30 years. I know the difference between noise and evidence. When a spouse testifies under oath about the location of a hidden safe, a safe that was not disclosed during 3 prior subpoenas, that isn't drama. That is evidence of obstruction. The media is focusing on the marriage. I'm focused on the law because in federal court, when you hide evidence that your lawyer swore didn't exist and your spouse tells investigators exactly where to find it, the legal term for that is criminal exposure. But here's what most people don't understand about what happens when a spouse's testimony contradicts official sworn statements and why this creates immediate legal jeopardy for everyone involved. So where does this leave us? Let me walk you through exactly what this testimony says. I'm not going to summarize it. I'm going to read you the record. Yesterday at 2:47 p.m., Exhibit 23B was entered into the court file. This is the transcript of a sealed deposition given by the former First Lady 3 months ago. Up until this morning, this was blacked out, redacted, hidden from view. Now, the judge has ordered it unsealed. Let me read you exactly what she said in the deposition. Page 47, lines 12 to 9. The investigator asks, "Was there any other location in the residence where your husband kept documents that was not accessible to staff?" Her answer, "Yes, there is a wall safe in the 3rd floor private office. It is located behind the portrait." The investigator asks, "Did you have the combination?" Her answer, "Yes, only the family had the combination." The investigator asks, "To your knowledge, was this safe searched during the response to the June subpoena?" Her answer, "No. My husband said that area was personal and off-limits to the lawyers." I want you to pause and understand the gravity of those 3 sentences. This isn't gossip. This is a witness with direct knowledge testifying under penalty of perjury that a specific location was deliberately withheld from the attorneys who were trying to comply with a federal subpoena. You've heard the term spousal privilege. I know many of you are thinking, wait, can she even testify against him? Here's what the law actually says. Spousal privilege exists, but it has 2 exceptions. 1, the witness can waive it, meaning they can choose to testify. 2, the crime-fraud exception. If the communication between spouses was used to further a crime, like hiding evidence, the privilege vanishes. The fact that this testimony exists tells me one of 2 things happened. Either she waived the privilege voluntarily, or a federal judge ruled that the privilege didn't apply because the conversation was about committing a crime. Either way, the evidence is now in the record. I'll be tracking every filing in this case, court documents, not media spin. If you want to follow the actual evidence without the noise, subscribe. But here's what makes this testimony particularly damaging and what investigators found when they searched the location she identified. 3 months ago, she sat for that sealed deposition. She gave them the location. She gave them the combination. So what happened next? We now have the inventory returned from the search warrant executed on that safe. Again, I'm not guessing. I'm looking at the return of service filed with the court. Agents opened that safe, and inside they did not find personal items. They found 47 documents. 47, and they weren't just any documents. The inventory lists them clearly. 12 documents marked secret for documents marked top secret, and 2 documents marked with SCI controls sensitive compartmented information. That is the highest level of classification we have. But let me show you what makes this legally significant beyond just possession. It's not just that he had them, it's which documents they were. According to the filing, 7 of these documents were specifically listed on a previous certification signed by the defendant's custodians. That certification stated under oath that these exact documents had been returned to government custody following a diligent search. Do you see the problem? You have a sworn statement filed in federal court saying document A has been returned. Then, 3 months later, Investigators open a hidden safe that the defendant controlled, and they find document A sitting right there. That is not an oversight. That is not a clerical error. In the eyes of the law, that is evidence of concealment. When lawyers certify all documents have been returned, and then investigators find more documents in a hidden safe that the lawyers were told not to search, the legal implication is devastating. It suggests the lawyers were lied to. It suggests the court was misled. And it suggests the retention of these documents was active and intentional. You've heard the term obstruction of justice. People throw it around loosely on cable news. Here's what it actually requires prosecutors to prove. We need an act, and we need intent. The act keeping the documents in a safe and telling lawyers not to look there. The intent, the fact that he knew they were there while his team was telling the government they were gone. Let me know in the comments. Does finding documents that were certified as returned change how you see the obstruction case? I'm curious what you're thinking. So what criminal statutes does this evidence trigger? Let me walk you through the elements prosecutors need to prove a new set of charges. When I prosecuted cases, I didn't look at headlines. I looked at the statute book. I looked at the elements of the crime. If I can't prove every element beyond a reasonable doubt, I don't have a case. So, let's look at this new evidence through the eyes of a prosecutor. What charges does this specific discovery? 47 documents in a hidden safe support, first 18 U.S.C. 1519. This is the statute covering the destruction, alteration, or falsification of records in a federal investigation. But it also covers concealment. To prove this, I need to show that the defendant knowingly concealed a document with the intent to impede or obstruct an investigation. Let's apply the evidence. Was there an investigation? Yes. The grand jury subpoena was active. Was there concealment? Yes. The safe was hidden behind a portrait and lawyers were told it was off limits. Was there intent? The testimony suggests he knew the documents were there. That checks every box for 1519. Section 18 U.S.C. 10001 false statements. This is the classic lying to the FBI statute, but it also applies when you cause someone else to make a false statement. Here's the legal theory. If the defendant told his lawyers, "I have returned everything," and he knew he still had documents in the safe, and he knew his lawyers would then repeat that lie to the Department of Justice in a sworn certification, that is a violation of 101. You don't have to sign the document yourself. If you cause your attorney to file a false document, you are liable for the falsehood. Third, 18 U.S.C. 371, conspiracy to defraud the United States. This is the broad statute used when two or more people agree to obstruct the lawful function of a government agency. If anyone else, a frantic aide, a loyal employee, a family member, helped move those documents into that safe to hide them from the lawyers, that is a conspiracy. This evidence, the testimony about the safe plus the recovery of the documents, connects the dots. Before this, prosecutors had to infer intent. They had to argue he must have known. Now they have testimony saying he said that area was off limits. That is direct evidence of control. When I prosecuted obstruction cases, here's what made the difference between charges and no charges. Evidence of active concealment. Putting documents in a box in a storage room is one thing. Locking them in a hidden safe behind a portrait and withholding the combination is something else entirely. That shows a level of calculation that juries understand. That's not a political judgment. That's a legal analysis based on what the statute requires. So what happens next? Let me show you the procedural timeline prosecutors typically follow when evidence like this emerges. You've seen the evidence. Now, let's talk about the process because the legal system doesn't run on internet speed. It runs on procedural time. Here's the typical timeline when prosecutors obtain evidence of this magnitude. Step 1 is what we call grand jury presentation. Prosecutors cannot just file new charges on their own. They must go back to the grand jury. They have to present this new evidence, the testimony from the spouse, the inventory from the safe, the contradictory certifications. This phase typically takes 2 to 4 weeks. They will recall witnesses. They might even call the lawyers who signed the false certifications to ask them, "Did your client tell you about this safe?" Step 2 is the vote. The grand jury will vote on whether this new evidence establishes probable cause to believe additional crimes were committed. If they vote yes, and based on the physical evidence of 47 classified documents, that is the likely outcome, they issue what is called a superseding indictment. You've heard that term. Here's what it actually means. It's not a new case. It's an updated version of the existing case. It replaces the old indictment with a new one that includes the new charges. It says, we are still charging you with X and Y, but now we are also charging you with Z. Step 3 is the arraignment on the new charges. Once a superseding indictment is filed, the defendant must appear in court again. They must enter a plea of the new counts. This usually happens within 48 to 72 hours of the indictment being unsealed. If the grand jury finds probable cause, the system moves automatically. The judge sets a date. The defendant is summoned. The charges are read. This isn't chaos. This is procedure. However, there is a variable here that we cannot ignore: the timing. We are in the middle of a legal battle over immunity and trial dates. The defense will argue that adding new charges now is an attempt to delay the trial or prejudice the jury pool. Prosecutors will argue that they have a duty to charge crimes when they find evidence of them, regardless of the calendar. But here's what makes this situation unprecedented and why the legal stakes are different than any obstruction case I've ever handled. We need to be honest about the territory we are in. This is unprecedented. No former president has ever faced obstruction charges based on spouse testimony revealing hidden evidence in a private safe. We are navigating a conflict between two fundamental principles of our democracy. On one hand, we have the principle of the rule of law. This principle says that if a citizen hides classified documents in a safe and lies to the government about it, they get charged. It doesn't matter if they are a plumber, a general, or a former president. The law is blind to status. On the other hand, we have the democratic process. We are in an active campaign cycle. Some argue, and the defense will certainly argue, that expanding a criminal prosecution during a campaign interferes with the voters' ability to choose. They will claim this is election interference by the Department of Justice. Legal scholars debate this. Can the criminal process proceed at full speed during an active candidacy? Or does the national interest in an election override the national interest in immediate prosecution? The founders didn't anticipate this exact scenario. They wrote the Constitution to prevent kings, but they left it to the courts to handle the details of criminal procedure. Now, the courts will have to apply established principles to circumstances they never imagined. You are capable of judging where you stand on this. Some of you see this as law enforcement simply doing its job. Others see a constitutional crisis. But here's what I know from 30 years in the system. The courts usually fall back on the evidence. If the evidence of a crime is clear, the process tends to move forward regardless of the political noise outside the courtroom. So, where does this leave us legally and constitutionally? Let's look at the bottom line. Here's what the court record shows. As of this morning, testimony has been unsealed. A safe location has been identified. 47 classified documents have been recovered, and many of those documents contradict previous sworn certifications. That is the evidentiary through line. You can't spin a document count. You can't argue with a search warrant inventory. Grand jury proceedings are secret, but the timeline is predictable. The grand jury likely convenes within the next 2 weeks. Evidence gets presented, witnesses testify under immunity, and then 23 citizens will vote. That is not a political statement. That is federal criminal procedure. The headlines will scream about politics. The pundits will yell about polls. But inside the courtroom, it's going to be quiet. It's going to be about Exhibit A and Exhibit B. It's going to be about statutes and elements. No one is above the law. That is the promise of the system. But everyone gets due process. That is the other half of the promise. Even in unprecedented cases, especially in unprecedented cases, we must insist that the process is followed to the letter. The evidence speaks. The system has a process for letting it be heard. Let's watch that process work. Spouse testimony revealing hidden evidence. Obstruction case strengthened. If you want to follow how this unfolds in court, subscribe and let me know in the comments. Does this evidence change your assessment of the